The Community of Justice of the ECOWAS has dismissed an application by the former Chief Justice Torkornoo seeking a temporal halt of the work of a fact-finding committee probing a petition for her removal. Justice Torkornoo had asked the court to issue a provisional measure to protect her rights and prevent what she described as irreparable harm while her substantive case is being heard. But in a ruling delivered this morning, the ECOWAS court held that the application was filed too late, more than 8 weeks after her suspension and over 6 weeks after the committee had already begun its hearings. The court said the delays undermine the urgency and exceptional circumstances required to justify a temporary halt of the proceedings. Meanwhile, Attorney General has been given 30 days to file a response to substantive case filed by the former Chief Justice. Now let's take a listen to the rendering of the ruling by the chairman of the ECOWAS court panel.
While the applicant met the 5-year timeline for applying for review, but their failure to satisfy the requirements of the new facts renders the compliance invaluable, as the requirement of admissibility of an application for review are cumulative. The absence of one of them is sufficient to endanger the admissibility of the application. In the light of the foregoing, the court hereby declares that the application for revision of judgment number ECW/CCJ/JUD/44/23 delivered on the 24th of November 2023 is inadmissible. And for that reason, sitting in public, the court declares that it has jurisdiction to determine this case. However, declares the application is inadmissible and orders each party to bear the cost. The full complement of this judgment will be made available to parties upon signature by panel members.
And so that was the rendering by the chair of the ECOWAS court dismissing the injunction application filed by the former Chief Justice Torkornoo seeking to halt the work of the committee that was investigating her removal from office. Now let's bring in private legal practitioner Austin Brako-Powers. Counsel, if you can hear me, first off, what do you make of the dismissal of the application for interim measure and reasons the court gave?
Yes, let me say a good afternoon to your listeners and those who are watching on social media. I think this is a sound judgment, because I have said earlier that, first of all, when you look at Articles 79 to 86 of the ECOWAS Court Rules of Procedure on interim measures, when you are asking the court to grant you certain measures, the request must be urgent. It must be in the nature of, there must be some urgency around it. And the police of fact and the law establishing the prima facie case for the interim measures will apply. Now, when you look at the surrounding facts, you realize that the dismissed Chief Justice waited for some time before applying to or filing the case at the ECOWAS court, the basis of which she applied for the interim measures. So she was supposed to have disclosed that it was urgent. But here's a case that she went to the court sometimes some months after the suspension. So there was no urgency around the issue. Do you understand? So I see the decision of the ECOWAS court on that basis, on the application, very sound, because there must be some level of urgency around it. Now you've been suspended for some time, you sat there, you sat on your right, you didn't challenge it, and you allow the substructure or substratum to change. Because the minute she was suspended, they had to appoint an acting Chief Justice. Then now we have a substantive Chief Justice. So the substratum, the foundation, the basis of which she could stage a comeback has been completely changed. So I agree with the decision of the ECOWAS court. Now, on the issue of the jurisdiction, and the jurisprudence of the ECOWAS court is clear that a mere allegation of human rights violation is enough to confer jurisdiction on it. And that its jurisdiction is established once the facts brought before it relate to human rights violation. And when you look at the application by the dismissed Chief Justice, she was citing or raising issues of breach of human rights violation. And when you and Article 9(4) of the 2005 ECOWAS supplementary protocol, it's clear on that. So I didn't see any reasonable justification for the government to, in fact, challenge the jurisdiction of the ECOWAS court. I saw it as an activity that will not yield any fruit. So basically, and the decision of the ECOWAS court today, I think it's very sound, and on two fronts, they've dealt with the matter as it should be, and the government should go and prepare their defense, because so long as the dismissed Chief Justice has raised issues of breach of fundamental human rights or violations of a human right, the ECOWAS court has clear jurisdiction under Article 9(4) of the supplementary protocol.
Now, we know the AG has filed 30 days to file a response to the substantive case going forward. Now, what legal strategy would you expect the parties involved to adopt?
No, I think clearly the government will want to go and say that, obviously the argument of the government will be that no, they didn't cause any harm, either reputation-wise or breach of a fundamental human right by dismissing her from her role or getting her out of her role. And that the dismissed Justice will also have to now marshal Asanas, defend why indeed she feels that her rights have been breached. I think we are in for a battle, but I know that if the dismissed Justice succeeds, she's likely to be awarded damages. So in some sum, it could be nominal damages, but the ECOWAS jurisprudence is clear. If you are able to ground a case, or if you succeed in proving a case of violation, on one front, you may be entitled to declaratory relief. But if you're able to prove damages, that you suffered some special damages, then in that case, then you'll be entitled to special damages. So it is now within the court of the dismissed Chief Justice to prove that, one, if there was any violation of a human right, those violations occasion some special damages or occasion some injury to her. She must prove these two things in order to be entitled to special damages, which will be in a various sum. Other than that, if she succeeds in proving that her rights were violated, she may be entitled to nominal damages as well as declaratory release, which declaratory release would be just to say that the government, indeed, by dismissing you from your office, breach your fundamental human rights. But would that be enough after she has been dismissed and her entitlement after so many years on the bar, on the bench, denied her? That would be an egregious crime, and that would be an affront to human rights. But it is early in the day. We are hoping that this will be a major battle ahead of the country.
Counsel, thank you so much for your time this afternoon, and that's private legal practitioner Austin Bracco Powers there.
Former CJ, not someone call ECOWAS court, no. From the report from the court, no meaning say court ne say or more jurisdiction to hear the substantive matter. In the Omashe AG say in 30 days time, no, was a AG file on also a response. Meanwhile, the applicant in this case, Chief Justice, former Chief Justice, SIF file an application for some provisional measures, which provisional measures was to stay the hands of the committee and their investigations. No say, hold it on, and on a court nika say the threshold of urgency, was not met. In Tianodie, or dismisses application, but on the substantive issue, the court say yes, or more jurisdiction to hear, and the Chief Justice prima facie etimi raise issues are here a court omutimi eshim. And that's the detailed report at the law platform at the etuja. And yeah, it was the two interlocutory rulings in a court and the one was to dismiss the application for provisional measures, and a one and so on the court's jurisdiction to hear the matter. No court no ruling say yes, for more jurisdiction to hear the matter, and calling on the Attorney General to file a response in 30 days. That's for the substantive application. That's what the law platform at the Atuja. Mamenkwa Omane so him say the former CJ the lawyer ni Ayikwe Otu Esquire, former Attorney General of the Republic of Ghana, and was served as Ghana High Commissioner to Canada, and so Eda ma yeneno ini enkomo. Council, good afternoon.
Hello.
Good afternoon and welcome. I hope you are doing well.
I am.
Good. Are you back from Nigeria? Hello.
Rather back on Asante many years when my friend passed away.
Yes.
Nobody calls me in the afternoon anymore.
So give us an idea. What was the ruling from the ECOWAS court today?
Well, I have been saying that, but I don't think what has happened is even newsworthy. Newsworthy in the sense that when the government as well as the committee started doing things which will prejudice FM. Some of us sounded the alarm bells. You see, if you remember, they had not finished hearing all the petitions. Out of the 3 petitions which His Excellency the President asked them to inquire into, they inquired into only one. And in an indecent, if they rushed and went and presented a report to the President, the same day the President said he had accepted the recommendation that the CJ be removed. When indeed they had not finished doing the other, petitions or inquiring into them at all. So if you are given 3 petitions and you finish one, where is the evidence that you have complied with the orders given to you or directives issued to you? Now, we did say that there were cases pending at the High Court and the Supreme Court, and that it would be better for all these things to be cleared out of the way before government embarks on making a nomination to the position of Chief Justice. The government didn't listen to us. It made a nomination. When a person was to appear before Parliament, alarm bells were raised in Parliament. The minority stood their ground to say that what we are doing is not fair. There are cases pending at the High Court, Supreme Court, and ECOWAS Court. So stop it. Just respect the boundaries of authority. The case is pending before the judiciary. You are the executive. Just respect the boundaries. The legislature, which is also an arm of government, can also hold on to respect what the judiciary will say. They will have none of that. And I went ahead, bettered him, and issued their report recommending him. Before anybody could say Jack, they went ahead and swore him in. You see, when you do these things, you are fixing the judiciary with a fait accompli. That's all they have done. That's what I'm saying. I don't know what they are celebrating. Because for all intents and purposes, as we see today, they have a new Chief Justice. So if they grant an injunction that the removal or the suspension of the former Chief Justice is not proper, would they reverse everything? Would they reverse it?
Yeah, but
so they are saying that for purposes of the interim injunction, let it go. What is newsworthy is the fact that they made a preliminary determination that indeed rights have been violated, and that the Attorney General is given 30 days to respond to the substantive matter, to give them an opportunity to hear the case. That is not an interim matter. That will be the substantive matter. So once the substantive matter, a judgment is given, which says that whatever they did was wrong, it will be left to the president. And here is Attorney General going about saying that whatever the courts will say, they will abide by it. I hope you have heard that one.
Yeah, I have.
So we are not worried about any. In fact, to make the point that in October, lawyers wrote to the ECOWAS court to say that the things have taken so long and that we are no longer interested in the interim measures.
Okay.
And that they should rather give us a date
for the substantive issue.
Those letters are also being circulated.
So for you as counsel, you were expecting the kind of ruling from the court on the application for interim measures, that the court may come to the conclusion they came to today, right?
Saying that we had even written the Nigerian solicitor, Falana, to the court already.
Okay.
That they should not waste their time on that matter, but should rather proceed to consider the matter itself.
Okay. And you had also applied for a default judgment. Is that the case?
Because they have refused to file their return from the time the matter went there.
Sure.
You remember recently in Parliament, Afenyo Markin made that point that they waited when the Chief Justice nominee was to appear. Then the Attorney General went to court to say that he wanted extension of time, and he was given 3 weeks to go and file it. So although they have been going about telling everybody that indeed there are cases pending before the Supreme Court, they had in fact not responded to any of them. They had not responded.
But
so this is nothing. I mean, I don't know what it is that we are talking about. Let me read this one to you. We have a little time. Re-institute Tomasuso and so Torkornoo versus Republic of Ghana notification on breach of lease pending and request for date to hear substantive suits. The above subject matters referred is: we are counsel representing the plaintiff in the above reference suit. The plaintiff commenced a suit seeking the enforcement of fundamental rights in relation to a position as a substantive Chief Justice of Ghana on June 30, 2025. Although the defendant was served with both a substantive suit and motion for interim measures, the defendant state elected to respond to the interim measures that were held on July 14, 2025. Despite the pendency of the suit challenging the plaintiff's suspension and seeking an order to restrain the defendant's state, the President of the Republic removed her as a Chief Justice of the Court on September 1st. That time, the motion had already been heard. He went ahead and removed her. Thus, this honorable court has been presented with a fiat in an apparent move to present this honorable court with a fiat complaint and thereby undermine the independence of the judiciary. Even though the defendant has disregarded the hallowed principle of least pending, the ruling of this honorable court on the provisional measures, by mark my words, will no longer be necessary. Let me repeat it. The ruling will no longer be necessary, as it has been overtaken by the contemptuous act of the defendant. We are, on account of the foregoing, compelled to request for the shortest possible date to hear the substantive suit. So what are they celebrating?
Oh, okay.
What are they celebrating?
And I think what also generated this controversy was in an attempt to update the rest of the country on what happened at the ECOWAS court, the Deputy Attorney General concentrated on the court's ruling relative to this, interim application, i.e., the one seeking provisional measures. And in his update, he made the point that the court has thrown out that application. In that update as well, he didn't touch on, the fact that the court has ordered the Attorney General to file their response in 30 days relative to the substantive matter. And that's what I think has created this whole, controversy on social media especially.
But they are playing politics. It's always in politics. So they are just playing politics. Just as they told everybody that they cannot work with her. They cannot reset the judiciary with her. And then when they come, they will remove her. So the whole thing was just trumped up. Got some people to write some petitions. Quickly got others. The Council of State to say we have found a prima facie case. And then they went ahead and removed her and set up a committee. Yeah. And you saw the reasons that were given, and they don't make any sense. How can a head of judiciary be said to have engaged herself in misconduct for transferring a worker? Not that he even dismissed the worker, but for transferring the worker. They say that amounts to, better misbehavior. And when the person in charge of the accounts, the funding officer, had explained that she was entitled to travel with other persons, they still said that for them, they owe the liable for whatever it is that has happened. I mean, you look at the grounds, there are no grounds, they are nothing. You said you have made a prima facie determination. It said, show me the prima facie determination to enable me to prepare so I can come and appear before your poor man committee, which you have set up. You said you will not have none. You will not give it. So she was never given the grounds for the so-called prima facie determination. Up to today, we have not seen it.
So you are saying when she wrote to the president that she would want to be heard before the prima facie determination, the president granted her that opportunity, asked her to respond, which she did, and then the Council of State, together with the president, came to the conclusion that there are some prima facie determinations that have been made. You are saying those determinations and the basis of those determinations were not made available to her?
Never, up to today. And meanwhile, you know the meaning of prima facie.
Sure.
It's just on sight, at first sight, at first blush. You haven't gone into the merit, but you just say that, well, I've seen some prima facie matters. So you go and see whether you confirm what it is that are taking place or what we have seen to be wrongdoing. For example, you remember somebody said she traveled and she was giving a per diem, and that she didn't retire the per diem. It was a blatant lie. She retired everything when she arrived back here. So assuming you have used this as a prima facie determination that she has refused to retire some monies, accountable interest. Now you found that what they are saying is wrong. You understand? But you never even showed them what the so-called prima facie determination was. But yet you ask her to go and appear before a committee and answer whatever charges have been laid against her. Now, if you remember, there were over 23 or 20-something charges. They said they found only 3 proving. And the 3 themselves were so hollow, useless grounds, that they said they have found that.
So, when you went before the committee may have read the details of the prima facie determination to your client for her response, no?
Why are you saying may have? If they did that, why should we complain? You said they may have, which is the same as might have. So you are only the man's thing. It's not true. They didn't.
They didn't do that?
Asking them several times. I met several. Those of you who have seen the reports, if they recorded them, if they did faithful recording, you will see it. We asked more than once, about 3 times, that we have not seen the prima facie determination, and we don't know what it is that we are answering. They won't mind it. Even at one stage, they told us that it is not for them to supply it to us. It was the president and the council of state, so we should go there.
And did you make that attempt to go there?
We didn't worry ourselves. Because if he says he has given it to them to confirm or deny whether those things are true, then they had it in their custody.
Yeah.
That is what they are going back. So they are the proper persons to give it to us.
As far as your client is concerned, I mean, based on all the pending applications before the court, which applications, if determined in her favor, would mean that her removal was unconstitutional? I get a sense that your client does not recognize the fact that there is, for the want of a better expression, a new Chief Justice in place, right?
Well, we're not in court before the new Chief Justice was sworn in. So what question are you asking?
No. I'm asking...
Are you saying we have now gone to court after he has been sworn in?
No, that's not what I'm saying. I'm saying because of the pendency of all the applications in court, you disagree with the fact that the executive should go ahead and nominate, vet, and swear in a new Chief Justice.
We said all that and they didn't listen to us. So what are you saying now? They didn't listen to us. We told them to hold on. You all saw what happened in Parliament. Even today, from what we are hearing, some majority people are saying Ato has brought the Parliament to disrepute and that it should even be punished for what he did. Now, what was it that he was saying? All he said was that there are cases pending. Can we please hold on? It was not the long and short. Was that not the long and short of all that Ato was saying?
Yes.
So we said everything. They didn't listen to us.
I believe you are still waiting anxiously for the court in Ghana to fix date for the various applications before the court here in Ghana, right?
You heard Ato saying that in the Supreme Court case, just like the ECOWAS, they refuse to file anything. All that they are interested in is in filing to contest interim orders. Because that one too, there was an interim application which went to the Supreme Court, the lead judgment being rendered by Mahamadu Bawumia, if you remember.
Yes.
So that one, they quickly filed their papers. In the same way, when we asked for certiorari, they quickly went there. When we were not given a date, then they filed saying that the court had no jurisdiction.
Thanks for watching. Like and share the video. You can also drop your comment. Please don't forget to subscribe. Click on the bell to turn on the notification.